Thank you so much for being this punctual and to give up your drink and be back. I'm sorry we're running 15 minutes late because of the rain. But that was a splendid couple of sessions which brought home one fact, which is that the one thing we can't afford to be is to be binary. And before I introduce the next session, I wanted to share just one tiny story about Anand Gandhi, which will bring home again the idea of ignition. Anand hates having that story told because, like Sumana, you don't want to be captured in just one identity. But Anand Gandhi actually spent the first 14 years of his life, not just in a chawl, but outside a chawl, in a tin roof, bricks, with not even a public, a toilet that was not even a public toilet. He was, as he says, execreting himself in the open. But the story was what helped him pull him out of that milieu. And so that encyclopedic knowledge, that curiosity, that scope and ambition, coming from a disadvantaged background, is again the power of the will and of ignition and of the story. So I wanted to share that story to bring home again just what was the level of genius that we were listening to earlier. Vis-a-vis the binaries, the next session is something that, at least for me, seems to be of the utmost significance in our country. Because like we were talking earlier about the value of the myth and of Indian myths, what really sets apart this civilization is its ability to hold complexity and many perspectives at the same time. And sadly, over the years, we're losing that genius, that capacity to argue across the aisles. So before I set up this next session, I want to share a story with you and to share that this really is almost like a modern day version of that, which is that Shankaracharya, when he was going around the country, bringing back the idea of the Vedanta, there was a massive debate that he had with Mandan Mishra, who was the custodian of the more ritualistic approach to the Veda, the Karn Kand, which was that if you do a ritual, then automatically you achieve whatever spiritual outcome you're seeking. But Shankaracharya was preaching something else, and they had a massive debate, a spiritual and philosophical debate. Now, Mandan Mishra had a wife called Ubhaya Bharti. And when Mandan Mishra, who was much older than Shankaracharya, said, "Who do you want as a referee to the debate?" Shankaracharya chose his opponent, his adversary's wife, Ubhaya Bharti, as the referee. So today, when J Sai Deepak and Saurabh Kirpal, two very distinguished, very incisive, very intellectual Supreme Court lawyers on the opposite side of a very important petition, agreed to come together on a stage in which I am the moderator. In a way, we are replicating that capacity and that spirit for dialogue across all ideological or all intellectual and value system barriers. Before we started this session, Sai said, as a value system and ideologically, you're possibly closer to Saurabh Kirpal's views. And before beginning, I do want to say, yes, maybe my value system lies there, but I'm deeply privileged to have both of them entrust ignition with this conversation. At the heart of it is a petition for same-sex marriage in the Supreme Court. It might seem that this is a case which pertains only to a community of those who find themselves identifying as people who love others of the same sex. But at its heart are many other very, very deep public issues of immense significance. First of all is the question of individual liberty versus community rights. The second is about liberal versus conservatives. Is there space for conservatives in a democracy? Is there space for liberals in a democracy? Who has the power to shift and change a society and nudge it to change its views? Is it the courts? Is it parliament? Or is it people themselves? And ultimately, at its core, is what is the role of a judiciary in a democracy? There are deeply divided views on this. Mostly when you hear about it in the public sphere, it's a lot of name calling. But today we're going to look at the much deeper, and that's why we didn't call it the hot debate. We called it the deep debate. Saurabh Kirpal is a Supreme Court lawyer that identifies as a gay lawyer. He was up for judgeship. There was a huge argument between the courts and government over making him a judge. And one of the key reasons he wasn't made a judge was because he identifies as a gay. So again, there's a big story and an important issue there about identity. On the other hand, we have J Sai Deepak, who has also written several books about the constitution called Bharat, that is India, that is Bharat, and also Bharat, India, and Pakistan, the issue of civilization and coloniality and Hindu consciousness. Saurabh has written books about sex and the Supreme Court. He's written books about 15 judgments. Both of them are erudite, incisive, and ready to talk. We are very privileged to be hosting this conversation. Ladies and gentlemen, please welcome Saurabh Kirpal and J Sai Deepak. Thank you. Yes.
I hope we can be more entertaining now that people are missing tennis.
Yes. I'm doubly touched. Not only tennis braved the rains and a Sunday, but to have a full house. That's an honor of all of you, all the sessions here today. Sai, as I already said, most of you would know, and I think I forgot that one little fact. Both of them are opposing lawyers in this petition, the same-sex petition. Sai is representing those who don't want same-sex people who love same-sex to have the right to marry. And Saurabh, of course, is representing the petitioners who want to have the right for same-sex marriage. So let me dive in here, Sai. As I said, there are many deep issues, but let's start with the particular petition. You said something very interesting, which is that you said they have a cause, but not a case. So let me start you with the role of empathy first. What is the cause that you believe they do have?
Thank you for giving me an opportunity to share space with Mr. Kirpal and to engage with this audience. I'm grateful to the audience for having braved the weather and for having made it all the way here. And in fact, there are quite a few people who have flown from different states to attend this debate. I don't think it's a debate, but let's hope we manage to make it one. So you started off by saying that I represented, or at least I'm on the side of people who are opposed to same-sex marriage. That doesn't sit well with the statement I made that they have a cause but not a case, which means I'm not exactly against them. In fact, just before, let me just give you an insight. I think this is not sub judice. Before my arguments commenced, I went and spoke with one of the counsels for the other side. I have a decent working equation with them, and I wanted to tell them, I'm with you otherwise on principle. I have certain institutional objections, which are largely technical in nature. My question has always been that if you choose to open the door of judicial activism for one particular subject or one particular issue, notwithstanding the fact that we may actually root for that particular cause, or we may want them to see something by way of a clear recognition. My fear is that an unelected body is capable of stretching the limits of that particular accommodation to other issues. And the world over, the one question that people have always asked is whether this concept of constitutional morality is fairly objective, or is it subject to the vagaries of the ideological leanings of the person who occupies that particular position. I refuse to believe that there is anything called objective anymore, at least not when it comes to some of these subjects. If someone has a position, they have chosen not to sit on the fence. Most are not fence-sitters. If they do happen to be fence-sitters, either they are uninterested or apathetic. But if they do take a position, they will tilt one way or the other. It's only a question of the degree of the tilt. So my position has not been contrary to popular perception and contrary to the memes or the trolling that I was subjected to, which I welcome, I don't have a problem anymore, is I'm certainly not homophobic. In fact, and I can reveal this without compromising on attorney-client privilege, two of the transgender petitioners who were on the side of Mr. Kirpal, their counsels went AWOL.
Sorry, what?
Away on the crucial day. And they were unreachable. I was reached out by both these people to say, we know that you have defended our positions in the past. Could you argue for us as well? So I had taken a position which is captured in writing in my written submissions, a very clear centrist position with respect to the starting steps towards what they want without violating the doctrine of separation of powers. Allow me to just make one point and I'll leave it at that. Some arguments are technical, which perhaps an audience which comes from the legal fraternity is better positioned to understand. And it's difficult to, or at least perhaps I may fall short on explaining that particular position. And in the process, the fact that my position was more about institutional boundaries and less about homophobia, and certainly not about homophobia, gets lost. And that is the nature of social media debates. This is my position. I need to clarify it.
Okay. Sorry. Can't hear. Okay.
Am I audible?
Can everyone hear at the back?
Okay. Oh, my apologies. My apologies.
Okay. Just
I'll just hold it.
be centrist.
Yes. I will.
Okay. Sai, you got away a bit, it's interesting, and I'm going to bring Saurabh into that. Like you said, at the heart of this, your argument is it's about jurisdiction. That do the courts have the right to nudge society to change, or should it be from Parliament, which is an elected forum and represents the will of the people? But am I right in saying that you think that they have a just cause and that same-sex marriage in some other forum, perhaps in Parliament, should be allowed? And if it was brought up in Parliament, you would be one of the voices backing it? Can we say that on record?
Okay, so I hope this is not one of those primetime television debates
No.
where they say pro, against
No,
this.
not at all. I told you this is a,
Right.
I'm
So
playing
let
the
me
role
clarify
of,
my position. So the position that I've taken is this. Barely a month before, am I audible? Yes, okay. Barely a month before the arguments began, there was a seminar on this very subject organized by MNLU, one of the national law universities in Mumbai. And I'd taken the very clear position that if you really want to take a position of least resistance, do not enter or stir the hornet's nest of seeking amendment through the judiciary of either the Hindu Marriage Act or any other legislation. Take the secular position, go under the Special Marriage Act. That was my very clear position. And this is on record because this is a recorded event that's available on YouTube. Second, what I said was that even if you take this position, it's going to be extremely difficult for the bench to justify to itself the ask. So therefore, why don't you actually ask something different, which is ask the judiciary to monitor the legislature in terms of pushing the ball on this and ask them to set the ball rolling and have a discussion at the very least. The unfortunate problem is in some of these issues, and I say this with no disrespect to anyone, interested parties usually are attached to the cause, right? And therefore, some suggestions which may not meet with their agreement in terms of the rigor or the vigor with which you wish to represent may fall on deaf ears. And therefore, I said there are better ways of doing this, because when you ask this, you're also putting members of the bench in a fix, and you're asking them to open a door, which is deeply problematic. So that has been my position. I'm not going to skirt the question. I will certainly support their cause, provided they do not interfere with religious aspects, simply because there are serious issues there, which are not in any way homophobic. In fact, the question would be, do you want the job done, or do you want to prove a point? That would be the simple question.
okay, I'm going to come back to ask you what is the religious point at stake. Let me just bring Saurabh in here. Saurabh, he's saying that there's a just cause, but the approach and the forum is wrong. So then at the heart of it is the question that should the courts play the role of a moral arbiter in a society where small groups, and I don't want to use the word minority because it's got infused with so many implications. Let's just say a group that does not have a large voice in parliament wants a right for itself and they approach the court. Is that the correct path, or do you think he has a point there that the court should not be playing a role in this?
Well, the 2 points that my friend Sai has made are, of course, mutually exclusive. You can't simultaneously say, go to court and get a judgment there, while also saying, don't go to court, go to the court of the people, i.e. Parliament. Right? You can't have them simultaneously, because you go to court when Parliament is not doing something. No one wants to rush to court if you are getting the rights that you deserve. And that is not how our constitutional scheme really works. Courts are a protection which have been given to minorities, and I don't hesitate to use that word, or indeed even the majority, because often you may be a numerical majority, but a political minority. For instance, women in our country are a political majority, and yet a large number of rights are denied to them on the basis of maybe religious laws, on sexual harassment. So the point is, you have no option but to go to court when your rights are being denied to you. You don't, as I said, rush to court for any and everything. It's only when you feel you are not being given your just dues. Now, I don't start from a position that everyone, like people like Sai, are homophobic. No, I don't judge people. I judge the argument that is made. So let's judge this argument that has been made, that the institutional power to determine as to whether there should be marriage equality. And again, I'll rephrase the term, rather than saying same-sex marriage, to be marriage equality. That if straight people have a right to enter into a union which gives their life so much meaning and purpose and is so important for them, legally, philosophically, from the manner of identity, then you are excluding a vast swathe of people and discriminating against them. And now those people, already in a minority, cannot possibly go to parliament and say, please do this for me, because really asking to reach out to the better side of an MP with whom you have no contact with is virtually impossible. Right? So the logistics of it can't happen. But that also does not matter, because our constitution does not require a disempowered person to suffer the indignity of being disempowered doubly by saying that the only person you can go to is that person who is oppressing you in the first place, i.e. the majority in parliament. Our constitutional scheme gives an option to such a person that when you are being oppressed, then you have an unelected body to go to. It's precisely because they are unelected that they have the power to come to the aid of those to whom the elected are not coming in aid of. Right? So it is a checks and balance situation, and this is how the system is created. So it's correct that you are not going to parliament and you're going to a different jurisdiction, but that is our constitutional frame. And our constitution is the very same document that has created parliament. It is not as though parliament predates the constitution. We have a system where you have 37% of the people which will return a majority in parliament of 55, 60%. We do not question that at all. We accept that because we believe in the constitution, we believe in the first past the post system, we believe in the idea of representation in that manner. We are all committed to it, and there is no question of illegitimacy when parliament passes an act, even though it is not backed by 50% of the people, because the constitution permits it. Well, the very same constitution also permits any individual going to the court and saying that my fundamental rights have been violated. And I don't see why that should be put to a higher judicial or a constitutional or social scrutiny than when parliament makes an act which is not backed by 50% of the people.
So I want you to come in there. You know, there are several things that have opened up, and as I shared with the audience, there are many things we want to unpack: conservatism, individual rights, community rights. You know, there are many things here. But let's stick with this for the time being. You said that they should go to parliament, but what happens in a scenario where there's a just cause, and I'm just saying it's this government, it could be previous governments, but the government, representing so-called the voice of the people, is actually arguing against this group. When 377 was struck down, and criminality of homosexuality was struck down by the courts, not by parliament, the government actually went to the Supreme Court to try and overturn that. Right. So clearly there's a biased social will there, which is against the fundamental rights of this group. In that setting, how do you think they would have recourse?
So I think, thanks to what Mr. Kirpal has said, I have to now bring in aspects of the law, and this is crucial. Now that I've clarified my position as to whether I'm homophobic or transphobic or whatnot, so let me now come to the actual question. Right? No, not you, I'm generally saying that. See, here's the point. I think at some stage, members of the legal profession must acquire some degree of humility to basically say, we can't be experts on everything from gynecology to ethnology. There are certain issues which require inputs from subject matter stakeholders and experts. I'll give you a direct example. What is the point of going to the legislature in the first place? What happens in the legislature? I could be at point 0, Mr. Kirpal could be at point 100. When you go to the legislature, the process is such that neither of us will walk away with our respective positions, but we'd be forced to actually come to a centrist position one way or the other. There is some kind of a compromise that is struck as a part of the particular process. Now you're saying that I'm going to keep every voice out of this particular discussion because I believe that I'm disenfranchised and I don't think I have a voice. And therefore, I will go to this particular institution, which has its own serious limitations, which have been exposed time and again on several issues, which require subject matter expertise, and then tell this institution that it's only a question of equality. Now, every time people draw a parallel between this petition, the issue in this particular petition, and the Nas Foundation petition or the Johar petition on 377, they make a mistake. One was a question of decriminalizing a particular act, and therefore it was a one-point agenda. But the other is the question of not recognizing just the right of equality, but the creation of an institution, because marriage is not just a concept, it's an institution. And if there are at the very least 600 to 700 attendant rights that go with the institution of marriage, from domestic violence to maintenance to child protection to whatnot, are we then saying that we will go to the court on a regular basis? Because this was one of the submissions made, and I'm sorry I have to make this point now. One of the submissions made by one of the counsels representing the other side, a very senior person, and whose erudition I have no doubts about whatsoever, except for this particular subject, who actually told the court, you declared that this is unequal, and we will keep coming to court, or leave it to future courts to decide how this particular judgment is sought to be applied or must be applied in the context of every legislation that has a bearing on the institution of marriage or something that is related to marriage. So are you saying that courts are only, every court in this country and every constitutional court in this country is going to be turned into a matrimonial court? That's one. Hold on. And second, here's the problem. When someone says we are a minority, sorry, the statistics say otherwise. There are, at the very least, empirical studies to show that you're looking at a population of 7 crores to 10 crores in this country. By what yardstick in a country such as Bharat, 7 to 10 crores constitutes minority for a particular issue? That is a question that you have to ask. 3, Mr. Kirpal said that you can't say on the one hand, go to the legislature, on the other hand, it can't be your advice, go to court. No. What is it that you use the judiciary for, or the forum of the court for? To ventilate a point of view. Sometimes you may not have a case in law, but you use that particular forum to actually stir the conscience of the legislature and the rest of the society in the hope that the point that you make through the court gets wider traction. People may wake up. This has happened in more than one instance. There are multiple examples to this particular effect. So the point was, use the judiciary as an instrumentality to stir the conscience and to get the debate going without violating certain boundaries. I respect the fact that the Constitution protects certain rights because the Constitution also protects what we call unconscious rights. Babies have rights, except that they are not aware of it.
Right.
Infants have rights.
So, if I may just come in here,
Right.
and Saurabh, I'm going to ask you to respond to this, but just to emphasize certain things that you're saying.
Yeah.
2, one is that the courts don't have the expertise or the jurisdiction
Correct.
to speak about personal laws or of these institutions. So one, would you say that the triple talaq case is not something that should have gone to court, but should have gone to parliament?
Fantastic. In fact, I've just written a piece exactly on this point. Be it triple talaq or Sabrimala, the best part is the judiciary itself has now framed this matter and has sent it to a larger bench. What have they asked? They have framed about 9 questions saying, we as a secular institution, which lacks ecclesiastical training in different subjects which relate to different faiths, do we have the ability to distill what is known as the essential religious practice of a particular faith in the context of a particular tradition? And do we have the ability to do so? And that question has already been framed. So in principle, I've taken the position, be it triple talaq, Haji Ali Dargah, hijab, or Sabrimala, the court, frankly speaking, does not have the ability as a trained expert on the particular subject. There are people who have dedicated themselves to the study of this particular subject. There are religious studies chairs all over the world. And you're telling me that a lawyer knows everything under the sun. Is that even possible? So when this question has already been framed, where you have recognized as an institution the serious limits of the application of your own judicious mind to some of these issues, why don't you relegate it to a better institution, which is the legislature? And I do not subscribe to the cynical position that the legislature is always to be looked down upon and the judiciary is always supposed to be looked up to. I don't subscribe to that school of thought at all, one bit.
Okay. Saurabh, I'm going to ask you to respond to that, but I just want to emphasize, I'm leaving one thought with you. He just said that there's not the expertise to speak on this, and maybe the wrong question was framed. Was it meant to be just an issue of fundamental rights rather than religious practice? So I'm going to come back to you to ask you on that. You made one other point, Sai, which was about inconvenience and sheer plethora of cases that will open up if equality of marriage is granted to those who love the same sex. And you said there's 600 other implications of that.
Inconvenience is not my argument.
Whatever may be, but
Right.
you're saying a plethora of cases will open. Will they keep coming back to the courts? The simple point is, here is a community that is not impinging. You know, you've said somewhere else that here you're trying to individualize a social institution.
Correct.
You've also said in the context of the same case that
Correct.
should society not have the right to draw red lines?
Correct.
Now, those are very subjective because who will decide those red lines?
Correct.
The institution of marriage itself is a very modern concept. In the Hindu tradition itself,
Is it? Okay.
we've been allowed to have 3 marriages and 100 wives, etc., right? So in this case, there's a group of people that feel their fundamental right under Article 14, 15, 19, and 21 are being denied. And that is not impinging on the rest of us from having children, dowry, property, etc., etc., etc. They are being denied a right. They're not trying to take away our rights to have children.
Correct.
So why is there even a resistance to expanding the rights of others when it's not taking away any from us?
Okay. What is the extent to which you're willing to extrapolate this logic? Because I have a couple of examples in mind.
Please throw them at us.
Okay. Assuming that there are 2 couples and they're interested in having a polyamorous relationship inter se. They're all adults and hopefully not brothers and sisters. Okay. They know what they're doing and they've chosen to enter into this particular relationship. Then there comes a point that this becomes a phenomenon where you realize that it's not limited to certain pockets, but there perhaps is greater acceptance to this, but in silent tones or in whispers. Okay? Assume for a moment that this particular practice acquires a certain critical mass. What is your position going to be then? Are you going to apply the harm principle to basically say that the institution of marriage is proven to be a failure, therefore let's do away with every definition or every notion that the society... No, hold on. If you're going to tell me that this is a hypothetical, this is speculative, sorry. I
wasn't going to say that. I was
Right.
going to say...
Right.
I was going to say, as a good lawyer, you can see the inherent contradiction in what you're saying.
And
because at one level, you're saying this must be the will of society.
Right.
If the will of society is to have polyamorous relationships,
Right.
how do you become the custodian to stop that?
And if the will of the society is to alter the nature of the constitution and to give this country a different identity, what's
Sorry,
your
I
position?
can't hear you.
If the will of the society is also going to be to change the nature of the constitution, hit reset on the constitution, give it a different rashtra altogether, will you give effect to that identity as well?
You know, you've changed. I was
No,
asking
the
you a
logic is
different
the
question.
same.
No,
the logic is the same.
No, logic is not
if
the
the
same.
society
but I'm gonna ask-
accepts something, you're saying it must be acceptable to the judiciary. If I were to end up convincing 90% of this community, or let's say of this country, to my position on certain issues, will you then accept it? Then I then say, I don't need to go to the court. I'll hit the reset. I'll use Article 368 and come out with a different constitution altogether. Republic 2.0. Are you okay with it?
Okay, you know, I'm going to get drawn into, I'm going to play referee and
got
not,
my answer.
not the discussant entirely over here. Saurabh, why don't you take, I mean, I have some views, but I'm not the discussant. Why don't you take on 2 or 3 of those questions? One was the expertise of the court. The other is what he said, where does this line stop in terms of what society can do if you open the doors on some of it?
Well, I think so. We have now moved from questioning whether Parliament can intervene from a constitutional perspective, which is, do they have the jurisdiction or not within our constitution? I hope we accept that they do. The question then shifts and say, well, even if they have the constitutional authority, they do not have the expertise. Now there, the argument is somehow fetishizing Parliament and saying Parliament has this expertise, the courts do not, right? Now that's simply not true, because we have all seen how laws are made in Parliament, how much, and many things are displayed, not necessarily expertise. Now, also, when we see the role of the court, they may not have the same expertise that Parliament has, but we expect courts to decide complicated questions. Now, Sai is a brilliant IP lawyer. They discuss and decide matters of immense scientific complexity and patents. They decide massive really important questions on financial issues, on the economy. If those judges can have the expertise to decide those complicated questions, then surely a question as to whether an opposite sex couple can have the same rights to adopt, to live, to have a joint bank account, to have insurance, to have the recognition of society can also be put for a same-sex couple. Now that does not require real expertise. That doesn't even require empathy. That just requires some basic constitutional common sense. So, I don't think, and look, there is some merit in asking courts to step away from issues that are in the political thicket. There is some reason to say courts must not jump into every issue. I'm not one of those people who say just because the matter in a cause is brought to court, the court must get in and decide it willy-nilly without being aware of their own basic, some inherent limitations. But when a cause comes which relates to fundamental rights, then it is no longer a luxury for the courts to say, I will not decide this. It is then part of the constitutional obligation. It is a part of a judge's oath of office to decide that question in terms of what the fundamental rights of the Constitution say. That brings us now to the second leg of the argument, which is that where do we draw the line? Now, that line inherently, of course, is subjective. But all law is at some level subjective. All constitutional values are at some level subjective. That which was accepted 50 years ago, 100 years ago, is not necessarily accepted today. Now, the words of the Constitution don't necessarily change. For instance, and you said that you have to keep on coming back to court again and again, where is the objectivity in that? Our Constitution recognizes caste-based reservations under Articles 15 and 16 of the Constitution. It permits that. Now, those two clauses of the Constitution about what equality means have engaged the court in the most complicated jurisprudence from 1950 till 2023. Views change of society and courts as to what equality truly means. Does it allow for reservations? Should certain castes be included in those quotas? Should a person who was a Hindu but then converted to Christianity, should they be allowed to have reservations? Now, these are complicated questions which we seem to have no problem if the courts decide because of these reservations. Because that is the nature of judicial decision making. And that is the nature of our Constitution. We hope this country will endure for the next 100, 500,000 years. The Constitution is what we have. Its words are written in stone. But if we tie ourselves down with that stone, we'll sink with it. We have to accept that some of the terminology used in the Constitution is inherently elastic. We have to trust the intelligence, the goodwill of our judges to be able to interpret those words so as to give justice to those citizens which they are obliged to under the Constitution. We trust parliamentarians, and as Sai says, I'm not one of those people who thinks that everything Parliament does is wrong. We trust parliamentarians, but we must also trust the judges. Put the same faith in the judges that the Constitution makers in 1950 did. Put the same faith in the judges that virtually every constitutional democracy across the world, US, the European Union, everyone, every place, we trust our judges to come to the aid when Parliament gets it wrong. And Parliament does sometimes get it wrong.
You know, Sai, I just... Saurabh, I'm going with Sai's argument. I'm going to play back to you in the next round. Some of the times when the...
I hope the fastest fingers first.
Yeah, when the courts have got it wrong. But before that, Sai, you know, you took it down into some very complex parts. First of all, you said that there's a religious issue at stake. Right. Now, in your books, you have been arguing that we have to decolonize our brain. Correct. We have to go with our civilizational ethos. Right. You know, we've been showing just a few of them, but if you go even with the Hindu civilizational ethos, Hindu civilization has had absolutely no problem with any color or any facet of the human experience.
Right.
You know, in fact, Varun and Mitra are same-sex couple that gave birth to Vashisht and, you know, we can laugh when it suits us, but it's Vashisht and Agastya. Vishnu fell in love with, Shiva fell in love with Vishnu, and that union as Mohini gave birth to Ayyappa, which is the Sabrimala deity, which is such a huge fight in the public space.
Right.
You have references in the Kama Sutra to lesbian couples that raise children together.
Right.
And you know, you can go to Khajuraho, you can go to other texts. You know, Khajuraho, there's a beautiful, I wanted to show it, but I was a bit edgy about it, but please go Google it. There's this amazing, beautiful image of women making love on the frieze of the Khajuraho temple.
Right.
So when you say it's religious, again, I'll quote back to you. You said the Hindu religion is like an ocean in which there are seas and rivers and ponds and multitudes.
Correct.
So who's going to decide which is religious? You said brothers and sisters should not be in a relationship, hopefully. But in Kerala and elsewhere, the uncle is perfectly legitimate as a marriage partner. In the north, that would be scandal. So do you agree that you are walking a very slippery slope? You said where should the red lines be?
Right.
Who will be the arbiter of that?
Okay. So there are 3 levels of responses here. I'm very happy with the examples you just quoted. First, I think Mr. Kirpal has misunderstood my point. Let me clarify this. I am never going to admit that the judiciary has the power but not the expertise. That's not my position. My very clear position is neither do they have the power nor do they have the expertise on the subject, is my very clear position. I am not making a concession here at all. It's surprising that a court which yields to legislative policy or executive policy on taxation, on defense-related issues, on all these issues, if this court, or let's say the judiciary, is blessed with all the wisdom that we impute to it, what happened in 75 to 77? These were instances where, on the one hand, we are being accused of fetishizing the legislature. Have there been no instances?
That was, you know, as a
No,
good
I'll
moderate.
have to make
that
my
was a
submit.
rhetorical question.
No, I have to
that's
make...
a submit.
No,
That's
there's a point here. There's a point here to be made
That's not a judicial
here. When we
question.
actually make the point that the judiciary makes no mistakes, who came out with the first decision on the NAS Foundation? It is the product of advocacy between 2013 and 2019 that you were able to change hearts and minds even with respect to Section 377, and I am the one who is asking you to put more faith in your advocacy. Second, are we saying that a court makes no mistakes? There have been instances where fundamental rights, which were otherwise meant to be protected, have been suspended by the very same court. When they were asked to bend, they crawled, is the very same language that's been used previously when it comes to even rights such as habeas corpus. So I don't think we should actually be making these statements with respect to the fact that the judiciary makes no mistakes or the judiciary has absolutely no subject which is beyond the scope of its remit or expertise. Of course there are. Now coming to the question of IP or any of these subjects, these are under very specific legislations where they have the power to do so. The question when it comes to this question is, this issue is whether they have the power. That itself is the issue.
Sai, may I step in here?
Yes.
Because I don't want to go down these too many of the tertiary parts. Let's
Right.
stick to the core, which
Right,
is
right.
about how does society change,
Right,
you know?
right.
Let me put back to you, and here maybe I'm presuming, but I feel both of you are not, you know, you're saying, does the courts never make a mistake? I don't think that's Saurabh's position. That can
Right.
never be anybody's positions. I mean, it's the Supreme Court that actually overturned the Delhi High Court
Right.
ruling on 377. I mean, it was
Right.
that backward, and
Right.
I'll use that word.
Right.
But let me come back to something which I think is fundamentally at stake here,
Right.
which is the fundamental rights of individuals. And here again, I would pose to you, is there a huge gap in your understanding of a democracy and his? And I'll ask him as well. You say that no individual's rights should supersede the rights of a community. That is not our constitutional position.
I'm not sure where you're getting this position from.
Sorry?
I'm not sure where you're getting this position from.
There's a
I'm
blow
not sure where you're getting this position from.
where I'm hearing that position
Yes,
from.
please.
It could be wrongly reported on Google, so forgive me.
Okay.
But here, the fundamental right is that two people in love want to marry. And Article 14, 15, 19, and 21, as we've said,
Right.
says that there will be no discrimination on people's rights insofar as their gender, caste, status, money, sex, identity, right? So this is something so fundamental. This is not an expertise issue. It's not a jurisdiction issue. A small group of people or a large group of people feel that their fundamental rights are not being granted to them, and it is not impinging on anyone else. Why is
Let
there
me-
resistance?
okay,
You haven't
there are two
answered
issues.
that.
There are two aspects. First, let's go to the Hindu example. Should I bring it up? Okay. It's convenient that we choose to bring about the liberality of Hinduism when it suits us, and then Hinduism becomes the subject of certain other discussions when caste is the issue. But anyways, we'll come back to the point. The point is this. I don't think we understand the role of the judiciary in a constitutional democracy, its interplay with the legislature or its interplay with the society in the first place. You're basically telling me that with respect to the creation of a right, this is not recognition of a right, this is also the creation of a particular right.
How? It's their recognition of a right.
Marriage
Their right to
is
marry.
not just, marriage at the end of the day has to be recognized by law. You can choose to call yourself married. Unless and until the law recognizes it in some form, it has absolutely no sanctity. So the question is about legal recognition. If it is about legal recognition, this is primarily within the remit of the legislature. Your entire argument has been, I choose to proceed on the basis that the bulk of the majority is against my position. I will not make any further efforts in trying to convince them otherwise. I have not set the ball rolling on the legislature. I don't intend to. I'd rather use the judiciary to get the job done. My entire position has been, it's not just about this particular issue. If tomorrow every other disgruntled litigant on issues which are close to their heart or causes which are close to their heart chooses to use the court to get the job done and completely relegates the legislature to the margins, what exactly is this democracy that you're actually talking about? If you're telling me that we need to protect the concept of a democracy, how is this democracy going to be protected if the legislature has absolutely no role in it? Where are members of the society going to get their say with respect to their concerns on this particular issue? Not every concern that has an opinion on this particular subject is necessarily homophobic or stands in the way of marriage. They want answers to certain questions. You are reducing this particular issue to its most, not simple form, its simplistic form to say, this is all about equality. Sorry, it's not just about equality. It is about creation of further rights. Because the bulk of the petitioners who are before the court are people who are asking for the right of adoption. And when they ask for these rights, there is a third party who is necessarily involved. There are institutions which have been created under the law for the protection of the rights of that particular third party who cannot speak for himself or herself. Are we saying that they don't need to be heard on this particular subject at all? On matters of science, on matters of taxation, on matters of even handwriting, court appoints experts. Are you telling me on such a serious issue, which talks about the creation of a social institution, not just an individual institution, the court doesn't need to hear experts? Ask yourself, in the 3 months or the 4 months or the 2 months that hearings took place before this court, which expert was heard by the court? What expert affidavits or opinions were sought by the court? Now, this is an institution which supposedly knows better than the legislature. If the legislature moots a certain proposal, there are parliamentary committees which are appointed. There are experts whose opinions are sought. Which expert opinion, other than the litigants' opinions, have been sought even in this matter by the members of the bench or this particular court? Ask yourself this question. Now, assuming for a moment...
May I draw him into it?
Please go ahead. Please go ahead. Yes.
So, Saurabh, you want to take on some of those questions? First of all, there are two that I can zero in on. One is about judicial activism. And he's saying that, the judiciary just can't keep stepping in and overturning or usurping the right of parliament. Do you think that that's a valid argument? And number two, this, I don't necessarily want to go into the process and procedurals because that's so easy. But why don't you take on that? Because he was being animated that the court has not sought the opinion of psychologists or those who could maybe represent the voice of unborn children, that will they be safe in a same-sex marriage home? Why don't you take on those two questions?
No, this is not about safety. I didn't say that. I think that's...
The rights of the child. You
rights
said
of the child from the
Or
perspective...
the interest of the child, let's put it
That's all.
as neutrally as
Safety
we
of the
possibly
child
can.
leads it in a very different direction. I'm not going in that territory at all. Mr. Kirpal knows what I'm talking about. That's not the issue at all here. I am not on the safety of the child. Well-being is different from safety. Let's not conflict the two.
I assure you, I don't take offense so seriously. Anyone who's grown up gay for 50 years doesn't take offense seriously. Right? We're used to a lot worse, and you, and my friend, are not a bad man. At least that's what I'd say. No matter what. So the question is, the argument is that courts are being asked to create a social institution when they do not have the expertise or the power to do so. Well, I'm afraid that's simply not true. Because that social institution of marriage already exists. A vast majority of you are married. I'm not saying create a concept which does not exist. What we are saying is, here is a social institution which, as you said, amends 600 laws because 600 laws exist to give a right to that particular social institution. Please extend the same protection of the laws, of those 600 laws which are good enough for straight people. Please extend the same social institution to those who are otherwise, in any case, disempowered. Now, I take an example about how this is not a creation of a social institution. I draw the memory of your audience into what happened in the US in the 60s and what used to happen in certain parts of India. That certain groups of people were not permitted to get married. Not just brothers and sisters. Those are interesting examples and make for good debating points. But the reality is that vast, larger numbers of people were stopped from getting married, namely people from between different castes or within the Gotra, as the Sagotra marriages were prohibited, right? So technically, or indeed, as I said, the US, where a black man and a white woman couldn't get married. There were anti-miscegenation laws. So there was this social institution which existed, but people were arbitrarily excluded from that social institutions as because of their innate characteristics, race, caste, subcaste, etc. Now, in each of these, I think we would agree that courts were right to step in and say, no, you cannot stop people from a different caste from getting married, and would intervene and say, this social institution, people of all castes should have access to. Now, what our argument in court was, is that a question of gender and sexuality is very similar to caste. Just as you cannot block access to the privileges, rights that a straight couple has by virtue of their gender and their sex, that same privilege must also be extended to everybody, regardless and irrespective of their sexuality. So that's the argument. It's not the creation of an institution. I certainly am not one of those people who, again, prioritizes or fetishizes the court over every other institution. I don't think the courts get it right every time. Very often they don't. That is why they provide for appeals. You know, if the idea is the judge is always right, there is no question of having a hierarchy of courts. Why have the Supreme Court? Let's just have Mufassil courts, because they'll get it right the first time. We recognize they don't get it right, which is why there is appellate provisions. There is a doctrine of overruling, because no one, save God, is always right. So once we accept that fact, so that argument is not being made by me or indeed anyone else, that the courts always get it right. It is a question of institutional competence and power. And that's correct. I would say that in matters of fundamental rights, where the very dignity of a person is involved, when the identity of a person says, I can no longer get married because my nation abhors me and does not permit me to live freely, openly, and joyously with the person I love, that frames their own sense of self, that touches their fundamental right, their idea of their own existence. And in matters which are so fundamental and personal, the courts don't have merely the right to step in, they have the obligation to step in, right?
Right.
Can I?
So, I want to, unless you're going to make a radically different point, because we are kind of circling.
Just one point. It's indeed surprising that when the question of whether it's the creation of an institution or recognition of an institution is being discussed, we don't wish to highlight the fact that all the material placed by both parties before the court clearly reveal that when the law was being framed, even in the context of the Special Marriage Act, which was meant to facilitate the very same intercaste and interfaith marriages, it was very clearly heterosexual in nature. Therefore, when the question was put to the other side, do you have any material to show that there was any kind of elasticity that was meant to be read into any of these provisions? They did not have an answer. The second question the court specifically asked was this: please tell us, how do you wish to apply the Domestic Violence Act in the context of same-sex marriages? How do you wish us to interpret these provisions? When these very clear questions came from the court, practical operational issues, because I'm not necessarily throwing around the bogey of 600 laws to say, let's stop this. These are very clear issues because there are welfare legislations and protective legislations that have come into existence to protect a particular gender. The question is, how are you going to identify this in the context of these kind of marriages? These are very real questions. We are not in the realm of speculation here.
So, Sai, just to keep the audience with us, here's and I'm just using the moderator's prerogative to cut you off here, Saurabh, to say that a lot of this will evolve. You know, none of the laws that were just, we've had 60 amendments and more of the Constitution, and a lot of things keep evolving as society changes, you know. Let's go back to dowry, widow remarriage, child marriage, property rights, you know, I mean, even women's right to their parental and ancestral property changed as recently as 2005.
Through legislature or judiciary?
Through legislature.
Thank you.
But I'm saying that things keep changing and evolving. So let's not get into the practicalities of this right now. Let's stick with the principles. I want to bring in a few more because, you know, we're going over the same argument. Do they have right? And it's a fundamental right. Just a couple of points. You've been saying that there is the space for cultural conservatism and that it should have a space in society. And if we're going to say that the Constitution is a liberal document, how are conservative people going to express themselves and what are their rights? So here I'd like to ask you this question, that where would you draw the line on conservatism? You know, if the Khap Panchayat doesn't want women to go to work or to have a gungat, and don't call me a liberal because I've sat in a train full of 6,000 Muslim clerics and asked them, why will they speak with a woman who's not a Muslim, but there's not one other woman in that train that was a peace train going from Deoband to Hyderabad. So I don't think that there's anything frozen about the Muslim community or the Hindus. I'm just asking you, when there's all these slippery slides of cultural conservatism, which conservatism do you want should be the arbiter of whether we eat, love, pray, what we wear? The government very often says that they want to define that.
Is your visual image of conservatism going to limit itself only to Khap Panchayats? Are you saying that there are no other shades of conservatism which are sophisticated?
No, many. Like a father that does, like there are many.
No, I felt that the example was perhaps it was stereotypical.
No, I was just evoking the easiest shorthand.
So that's the problem with the shorthand because then it loses nuance. The point I'm trying to make is this. I am not on the question of whether conservatives must have the right to draw a line. The question was entirely in my submission, you can play it out for everybody's benefit, was, do people holding a conservative point of view not have a seat at the table when this issue is being discussed? Are they not participants to this particular discussion in any way? They can be wrong. They can be 100% wrong. But are you going to deny them the right to participate in this discussion by having this closed-door hearing, so to speak? Because it is a closed-door hearing when the rest of the society doesn't get to participate in it. You cannot compare the scale of this particular discussion or its comprehensive nature or lack of comprehensiveness, so to speak, with what happens in the legislature. So the point is entirely this. I don't think that the conservatives must effectively have the power of veto. That's not been my position. But they certainly have the right to participate in those conversations. And this forum and the nature of this proceeding does not lend itself to multi-party stakeholdership representation, thanks to the nature of the forum. It's not on this particular issue alone, on several other issues. So I'm not going to sit and say, this should be the line that conservatives must draw. Did you see me ventilate that particular position in court? No. Because I don't need to make that particular argument. The entire argument was, give us a seat at the table. Don't make this an elitist conversation where we have absolutely no space whatsoever. That's been the nature of the discussion. That's been the ask. So why do we need to actually look down upon the conservative position?
May I ask you a question here? Saurabh, how would you respond to?
Well, that argument, if stretched to its logical conclusion, would require us to erase courts from our constitution altogether. Because every time courts decide something, for instance, in a matter of fundamental right of free speech, right? It's not as though they're deciding that it's valuable free speech or not, that they'll conduct public whole surveys and then take a decision. They're obviously not. So if every time the courts are supposed to give everybody a seat at the table, so to say, then they will never decide a case because that's not how a judgment is made, right? There are two parties before the court, and very simply, someone as competent as Sai is also free to come and put the conservative point in court. That happened, right? We heard the government making arguments which were against the liberal position put forward by the petitioners. So who was silenced? The problem is not that the conservative voice was silenced. The problem was, where was the conservative voice meant to be heard? And I don't believe that there is no place for a conservative voice any more than there is no place for a liberal voice. In a free democracy, in a free country, there is a place for every stream of thought, including on this particular podium. The question, however, is that when you say that because there is a lack of hearing of the conservative voice, to me sounds really, if you unplug it enough, argument against the court exercising its jurisdiction in favor of the liberal point of view, right? That's the sum and substance, really, if you unpack the argument. Because how was the conservative position not given a seat at the table, or how was the liberal position given a greater seat at the table?
Yeah.
Judges are deciding, right? The judges are deciding between left and right, between conservatism and liberalism. Both sides are heard. So if you say the conservatives have no place, well, equally the liberals have no place as well. That's not what happened in court.
Okay. Okay, let's just, we're going to run out of time. I'm going to take a few questions. Unfortunately, there's just so many positions that we really want to examine, which we haven't even gone into. I'm just going to ask both of you a contrary question. One is, let's leave the same-sex marriage aside. I hope that this is argued out in court. When we're saying that the government itself is playing the conservative position in this case, it is arguing against the rights of same-sex couples. So I think the conservative voice is being heard. But Saurabh, let me bring you in here into a criticism that the right wing often throws at those who are called liberals, which is that where the Hindu framework is concerned, liberals are always pushing and criticizing the Hindu right for being conservative, for being patriarchal, for being fascist, etc., and pushing for liberal positions. But the moment it comes to Muslims, bizarrely, liberals take a very conservative position on Muslim issues. Suddenly you're pro-hijab, you're pro, triple talaq, you're many things. It becomes that the clerics of the Muslim community are the voice of that community. Do you think that this is a valid criticism of the liberal position from the right? Do you hold it yourself? And do you think this needs to change?
I think that's a very valid criticism of a certain section of liberals, particularly those politically inclined. An intellectual liberal will not have that position. I certainly don't. When I see injustice being meted out, I have to be blind as to who's doing that. Now, if it is within the Muslim community, there is no question that the court must intervene. Unlike Sai, I believe the court was right to step in and strike down triple talaq. It is a deeply offensive practice and has no place in a modern democracy governed by the rule of law. And any time that someone says, so that is a principle that I must take, a principal position. On hijab, now, there again, I am not a fan of cloaking women and removing their identity. So I'm not a great votary or a fan of hijab at all. The question is, how do you go about it? But that again is, that's not something that was done by the courts at all. That was done politically. The matter went to court. I think the courts do have jurisdiction on ruling as to whether hijab is constitutional or not. Right? What they do is another thing. So here again, we must not conflate jurisdictional issues from the values that we hold. But the criticism of the right sometimes is justified because sometimes the excesses of other religions are allowed to stand. And there is no place for that anywhere. Equally, there is no place for injustice within the Hindu community. So I don't think we should get drawn into this whataboutery. We must realize there's a bigger problem out there, which is patriarchal society, where women are oppressed in society, and therefore the laws must move in, both courts as well as the legislature, to even the scales for women. We are still a caste-ridden society. There is no question of it. So there is a responsibility to move in and address those issues. So to some extent, if an argument is made that we turn a blind eye towards the ills of a community because we claim to be liberal and liberalism is somehow only anti-Hindu, there I don't think that's a good position.
Since he's conceded that, I'm going to come to you for a quick concession, Sai, which is that you've been saying that things have to be that some things are decided as a heteronormative. You've used this phrase, or is this Google wrong? Okay, so when you say heteronormative, isn't that a very, very problematic concept? Because again, there you're putting power into the hands. What is heteronormative and what is normative itself? Right. And here I wanted to use the example of, say, the Fogart sisters, where normatively they would not have been allowed to be wrestlers, boxers, cut their hair short, do any of what they were to do. They are parents who are in very normative societies where an individual feels the urge to break from a norm.
Right.
And the Constitution has been built to support those individuals who want to break from a norm.
Right.
Whereas the heteronormative always tries to keep status quo and conformity.
Right.
So are you going to say that we must subscribe to the heteronormative? How will an individual ever break free? And here I want to go away from the Indian context and let's take black rights. You know, so it's not an emotive issue.
Right.
Back in 1700s, blacks were seen as property. And you know that famous case where in a ship that was going to drown, the owners of the ship threw 350 blacks into the ocean so that they could claim insurance. That was the normative behavior.
Right.
It took a court to overrule that. And it took another 100 years before society caught up with that. So the normative behavior for the whites was that blacks are just property and non-human.
Right.
It took individuals to break that norm. So let me ask you a value question here, not a legal question.
Yes.
Are you in favor of individuals who are seeking to express their liberty and break with the normative behavior of their societies? Which would you support as a value?
Could you please explain where this question is coming from and why is this being put to me?
I'm asking it as a value question.
Fine.
I've asked him also about, you know, this blindness towards, say, you know, regressive practices amongst Muslims.
Right.
Liberals take a default position which says, oh, they must have their rights.
Right.
So I'm similarly asking you.
So first point, I think the concession that Mr. Kirpal has made, I would compliment him for it.
Sorry?
I would compliment him for it because I would say he's truly in the minority for having made the concession. Two, and since you've claimed to have read my book, or at least you have an idea of it, I have abhorred the use of the word right in the context of the position.
The use of the word?
Right.
Right.
In the context of the positions I take. Because I do not subscribe to right wing for a very clear reason, that it has extremely racist, genocidal, and colonial connotations which I do not relate to under any circumstances. Those who subscribe to the indic position are the people I subscribe to or I relate to. So mine is not the right wing. I've clearly said mine is the indic wing. That's one. Second, in the written submissions filed before the court in this very same matter, I've asked for NHMU, non-heteronormative marital unions, to be recognized through the legislature, at least by way of partnerships. That's a very specific suggestion that I've made as part of my written submissions. I did not bat for heteronormativity. I basically said, by and large, societies tend to be governed by majority will when it comes to deciding the norm. However, that does not mean that what is not the norm does not exist. And this is where I go back to the Hindu question that you put to me. The Hindu position in the context of the Tritiya Prakriti or in the context of non-heteronormative relationships has been to give them a position outside of the Shastras, as opposed to saying, let's amend the Shastras itself. And second, their institutions were protected. They were actually given protection even when it comes to agricultural produce. Why? Because you see members of this community begging at the traffic signal today when they do not have anybody even giving them opportunities of livelihood. This is the manner in which the Hindu community has taken care of this particular non-binary gender identity. So in fact, during the course of my arguments, I specifically submitted, start with at least the basic of Maslow's needs when it comes to what this community faces day in and day out. And the reason is, I've worked with members of this community in addressing issues of human trafficking, which is what they're ultimately subjected to. They are actually sold as prostitutes across. Do you want to know the name of the gangs which are called Jamaats, in which they're actually sold? This is the name of the groups which actually trade in transgender prostitutes, so to speak. So I said this is the issue that you need to start with at the very least. So I'm not batting for heteronormativity in every sense to the extent of saying wipe out every other identity. I'm merely saying that allow the society a say and put faith in your advocacy to reach out to the society and explain your point of view. Because if you're going to use the judiciary as a means of top-down imposition of any initiative that you want, the societal acceptance that you actually ask for or that you're craving, you won't get it. And I don't see how is it that the court's imposition of a particular point of view without bringing the society into the picture.
I'm going to stop you from making that point because both of you made that point enough times.
Please.
I'm just going to end this with one last question to both of you. which is that when you say that society should engage with society and with government, in this context, Sai, and I'm asking you, obviously, you know, I'm not trying to make you the spokesperson, but why don't you refract a certain view of the world?
Right.
Is that in our society today, and that's why I brought up this Mandan Mishra and this kind of dialogue we are having, this good faith dialogue is just not possible outside in the public. Whether it's the left, which will call the right fascist, or the fascists, which will call them non-Hindu, or Maoists, or I don't know, innumerable things. You yourself in an interview recently said Barkhadat, Ramala Thapar, and
Yes, I did.
Irfan Habib should leave the country
I
and
didn't
not.
say that.
You said
I
who,
didn't say that.
you were asked rhetorically,
Right.
who are the three that should leave the
Correct.
country and never come back, and you
Correct.
picked these, you know?
Correct. Yes. And
Now-
I gave my reasons also, and I stand by those reasons.
Right.
Yes.
But just the fact
Right.
that we are asking each other to leave the country,
I
we are
didn't ask
asking
them to
each
leave the
other to be un-Hindu or
I do
Hindu.
not. I do not.
Do you, one
At the
minute, let
very
me
least,
finish
you
my
shouldn't
question.
cite Ubaya Bharati's example if this is going to be a line of questioning. Then you'll have to give me an answer to
No,
an opportunity to
let me
respond.
just finish my question.
Right.
When you are asking society to engage, those who disagree with government, or
Right.
those who disagree with the heteronormative, or those who disagree with the majority,
Right.
would you concede that it's very worrying that in a society to engage, protests should be allowed without it being called, you know, foreign hands funded, or anti-national, or ready for sedition, or being pushed into jail? How should society dialogue when protesters are not even allowed to be in Jantar Mantar, but they must now go out of sight so that their protest is not heard? When Parliament does not ask for committees, when Parliament does not allow for discussion, when the opposition itself is discredited, you know, how will society dialogue? Do you think this is a crisis?
Is it your case that all protests are genuine?
Yes, I would presume until there's extreme empirical evidence.
So, hold on.
To the
So,
contrary.
Does the state have the right to prove at the very least that not all protests are organic and genuine? Yes or no?
May I answer that without a yes or no, because we're trying to not be binary.
Thank you.
know?
At least then I should be extended the very same courtesy.
Yes.
Proceed. Yes.
So my point is, and I'm Saurabh, this is becoming I have to step back a little bit, draw you in here.
Right.
Sai?
It's rather like watching the volley in Wimbledon that we're all missing.
Yeah.
Please go on.
Sai, I'm going to bring Saurabh in here to answer this actually, but when you ask that
put
question,
the
when you
question,
ask
you
that,
answer.
when you
Yes.
ask that question,
Right.
I would in fact say, as a journalist, woman, citizen, any other identity I wear, I would deeply urge the government, media, and everyone else
Right.
to provide empirical evidence before they do any name calling
Right.
that is currently going on in our public life.
Okay. So when they launch prosecutions, which is well within their power,
Sorry?
when the government launches prosecutions with respect to certain protesters, or even journalists for that matter, who they know for a fact or they have material to believe have not exactly been true to Indian interests, are you saying that the government has no right to prosecute such people merely because they happen to be protectors of free speech and they are in exempted categories such as journalists?
No,
Yes.
what I, as a journalist and a woman and a citizen,
Right.
definitely disagree with
Right.
is the right of the government to frame people in certain contexts and in certain languages, and that could be any government, and that cuts across many dispensations.
Right.
Right now, it's the center that we're discussing. They'll say, we have this knowledge, but we don't need to put it in the public space.
Okay.
And they often do that.
Did
so
you ask
people,
this question before 2014?
before 2014,
Yes.
very
Did you
much
ask this
so.
Question?
Very much so.
In what context?
In the context of Binayak
Did
Sen.
you ask
and-
it in the context of Section 66A?
Yes.
When?
But wait, Sai, you're dragging me down specifics.
No, you've asked
Hold
me a
on.
question. Now I have,
No,
now
hold
the
on.
floodgates have opened. I have the
66A.
right to respond.
I feel like you should
66,
gut in at this
right.
point.
Saurabh,
because
let-
60
let
No,
me
I have
bring
to
you.
answer this point
Just
because since you've
before
asked
you
me this
yes,
question, let me
sorry,
answer.
maybe we can reframe the thing. You mentioned 66A.
Would you share with the audience what 66 is?
66A of the Information Technology Act was a section that permitted prosecution of material electronically propagated that had a tendency of causing annoyance between people, or two people. It was misused very often, including when some statement was made against Thackeray or against various leaders. Now, the only reason I wanted to intervene, and then I let you have it at each other,
No.
is a point that we sometimes forget that politics is the same. It doesn't matter whether it's the BJP or the Congress or party A, party B, party C.
That's the point.
66A, just to remind the audience, was brought in by the Congress regime when it was part of the UPA.
Defended by the BJP.
And then, yes,
Correct.
when it is finally challenged
Correct.
in courts in 2015,
Correct.
it is defended by the BJP government.
Absolutely.
Because every government wants to suppress a citizen.
Correct.
That is what they want.
I am so happy.
That is absolutely what they want. It is the courts. Now
Well,
we
let me answer
disagree
the
on the role
question.
of the courts.
I'm happy to
It is
answer
the
the question
courts
here.
who have to step in to
Right.
protect the citizens.
Right.
We must have every freedom. You know, as a society, we have given up on having freedoms. We've kind of grown up in a milieu where we cede to the community, which starts from our family first, to the larger family first, all our rights. We just don't value our freedoms. We don't see them as important. We don't see them as worth fighting for. And I think we have to start that, remembering that every government is every party, every politics, all authority will want to wrest your freedoms and exercise control over them because there are institutions of control.
That is the nature
We don't
of
need
power.
to go to Foucault and those.
Fantastic. Correct. Now, if that is the nature of power, and now I must have my turn to respond, here's the question. Prior to 2014, and when there were issues of 66A and several such provisions, when was the last time, or at least during that particular period, words such as fascist, majoritarian, anti-free speech were used in the context of the dispensation then? So I agree, the nature of power is that it's capricious, it will only seek 100% loyalty. But the funny part is, those who are expected to call out such people conveniently changed their positions before 2015 and post 2014. And I have to ask this question. If journalists have a higher degree of responsibility, or let's say higher degree of protection because they are in the business of enabling free speech, what would you say of a journalist who goes after a person who criticizes her in a suit for defamation or in criminal prosecution for pointing out the unfairness of a reportage in the context of an incident that concerns national security? And I refer specifically to the incident of Mr. Chaitanya Kunte being prosecuted by Ms. Dutt for defamation. What is your position going to be on that particular issue?
So,
Governments prosecuting people for violating the law is within their remit. We are being told that free speech is elastic when it comes to journalists. What do you make of a person who says that I have the right to prosecute this person because he has criticized me or he's defamed me? Then what is your position on that?
Sai, I'll say it absolutely categorically. And unfortunately, I've become the
I'm asking for a
discussant here,
concession
but
from you
I'm
now.
telling you categorically that I am on record, contrary to my tribe, to say that because journalists and media have so much power, I absolutely endorse and absolutely believe that the public must have recourse for defamation cases against the media.
What about journalists against public for criticizing for their work?
And I absolutely think that right now, journalists are overstepping the line a lot.
Always.
On this case, I would say that it is wrong. I think as long as you have the right to put out any public story, anybody has the recourse. If they feel injured by your actions, they have the right to come for recourse
for the
against you.
concession. Thank you.
Absolutely, without a doubt.
Thank you.
Why certain things become nuanced is in the past, it's been to protect journalists from large corporations.
One final point, and I'll leave it at that. We are not looking at stifling of free speech. The fact is, a voice such as mine, representing the worldview that I do, wouldn't have found a space on any platform prior to 2014, and that is a reality that I've lived with.
So, okay,
So
Sai,
today when someone comes and gives me these lectures and gives me the spiel on free speech, on Vaad and Samvad, I say it's mighty convenient. Times have really changed. The Overton window has seriously changed
And if
because
I
people
may-
did not do that before 2014.
If I may step in there again, because I feel I should. It's correct that maybe a conservative voice would not have gotten place prior to 2014. A fact which is unfortunate, a fact which is deeply troubling. But that does not mean that having got that voice, every other voice is pushed off the table.
Where is it? There has to be some evidence to
I'm
back
not
that
saying
particular
that.
statement. Where is it?
I'm not saying that
Which
you're saying...
platform has been stifled after 2014?
I'm not saying that you're saying that. What I'm saying is we must remember as citizens that free speech is valuable because it protects all of us. And the question is, what is the content of that free speech is not something that can be judged unless it causes harm. That's a classic liberalism. It isn't very much. It's liberalism 101. Everyone should get access to free speech. Every act which harms, including defamation, needs to be curtailed. These are basic things. Sometimes we get just so carried away but the polemics of it, with the extremes, that we forget that the vast majority of people today started self-censoring, both from worry from the left or the right. And self-censorship is possibly far more worrying than governmental interference. The government really doesn't need to come in and stop you from speaking very much. The fear of what the outrage will be, both from the left and the right, that's sufficient.
My point has been that we have discovered the values of liberalism when the shoe has been on the other foot. Thank you.
I was a lawyer who challenged Section 66A. So I was against 66A, both for both parts of the government.
Sai, it's good you asked this question because as a journalist, and you can go back and look at Tehelka's history, personally, we did a cover story on 66A, very, very critical of the Congress government, and he said the same. I just want to pose one question to both of you to concede, and then let's go for dinner.
Right.
You said before 2014, the liberals had a voice, conservatives didn't, and that's very fair. My question to you, and actually my anguish about this moment in our history and in our national life, is that when certain things are being articulated and new voices come, why is it such a revengeful voice? Can you not put forward positive voices, positive positions, without saying earlier we didn't have a voice, so now let's push these guys out of the frame and call them anti-national, anti-Hindu, etc., etc. You know that this vocabulary happens.
I'm so sorry. When I walk into certain institutions located out of Sonipat, I had posters actually saying, Brahmin, go back. This is the language that's been used. And these are institutions that have been posted institutions for liberalism in this country. I'm not naming that institution only out of decency. And this is a post-2014 phenomenon. This is as early as 2017, or rather as late as 2017. So when someone suddenly says that we are being edged out, or we are being, our position at the table is being taken away, I can only see that post-2014, the number of institutions which represent the worldview that you stand for have only mushroomed. They have not gone down. I haven't seen a single institution say closure sesame because of government action. It's actually mushroomed. On the contrary, I have seen more and more people releasing each other's books, despite the fact that they come from opposite ends of the ideological spectrum. So I haven't seen this. So I suspect that this is a grievance without a cause, because perhaps there is some kind of a brownie point that is sought to be scored here, that we are more liberal, look at this is a vengeful tone. Frankly speaking, I have said everything that I have said in a very composed tone only for one reason. Because I stand by the position that I have taken, and I don't need to raise my voice to make my point. I have never been accused of that. On the contrary, there have been instances where my pieces, even post-2014, have been returned by left-of-center publications. When I said this article needs to be called out for its inaccuracies, they said, sorry, you won't get a voice. This has happened. This is post-2014. So it's not as if suddenly you've lost the power of your veto. You've always had it. You continue to have it.
Okay, let me end on this note. I would say that the question of individual liberty and conservatism is a question that, is important to all of us. It's something we should take home with us. I would say that I cringe at the fundamentalism of the left, and I mean that, Sai, and I'm saying it on record. I would love it if on record we could all say that we cringe, or if you cringe when the right expresses itself clumsily, angrily, and with name-calling. If you can say that on record, we would have arrived somewhere center. Saurabh has already conceded that
I don't relate to the right. I'm not associated with the right. I represent the Indic view. I don't speak for them.
So when the Indic view speaks in a cringy way about those who don't agree with it, do you cringe?
Let me echo Mr. Kirpal here as a person who believes in free speech and as a reasonable person. Anybody who does that is wrong. Anybody who stifles the other person's point of view or takes away his ability to vent, or her ability or their ability to vent their point of view, I do not agree with that particular position. I don't need to agree or disagree with anybody else specifically.
Or send tax officers on them.
Sorry?
Or send tax officers on them.
As long as they don't launder money.
All right, I don't think we arrived at any particular conclusion, except that what is at stake here are three things. Do the courts have the right? Is this a fundamental issue of liberty? And do others have a right to enter that conversation? I think at the very least, it's woken us up to a case that goes beyond just the community and affects all of us, because what's at stake is our ability to speak with each other. Thank you very much, Sai and Saurabh, for being here, missing your Wimbledon, and allowing this conversation. There's dinner outside, and there's drinks here. Please join us, and let's continue this conversation. Thank you very, very much, all of you.
How do you start an iconic movement?